This is an area that the committee has had a particular interest in, and certainly I have an interest in it, not least because of the obvious advantages in terms of to the taxpayer because of the expensive nature of resolving disputes through the legal system and in our courts, and therefore this is something that I think can actually be quicker and more cost effective and ultimately can lead to better outcomes. So let me give you the official speak. They're my opening thoughts on it, but the concept of alternative dispute resolution as an alternative to court proceedings has received greater prominence in Northern Ireland in recent years, particularly in light of the report of the Access to Justice Review Team. The Access to Justice Review Team, published in August 2011, considered that the availability of a menu of alternative dispute resolution mechanisms for different types of legal disputes enhances access to justice and should be promoted by the Department and stakeholders within the justice system. The committee has taken an interest in the issue of alternative dispute resolution in the wider context of the Access to Justice Review recommendations. The committee has been briefed by the Access to Justice Review Team on the findings of its final report and by the Department of Justice on responses to the review recommendations. The Department reported to the committee that there was broad support among consultees for developing alternative dispute resolution mechanisms and that it would carry out a comprehensive mapping exercise to see what mechanisms exist. During these briefings, we explored a number of issues relating to alternative dispute resolution, including encouraging the use of alternative dispute resolution in family law and other types of disputes, such as neighbourhood disputes, community disputes, antisocial behaviour, qualifications of those who practice alternative dispute resolution, and the contribution of alternative dispute resolution to faster justice, amongst others. This area is something, if I can draw on even on my own local constituency context, only last week I was engaged in some of our working class estates where they are actively having dispute resolution systems rather than having to involve the police to avoid people having to even interface with the criminal justice system at all. Obviously, there are circumstances where very clearly you must use the criminal justice system, but often in respect of antisocial behaviour and neighbour disputes, if a process can be set up to facilitate a resolution of that locally, that ultimately can beat everybody's outcome, and there is ongoing work supported by the police for local neighbourhood disputes to be resolved rather than having to legalise and often criminalise things which don't necessarily need to be the case. The committee also commissioned a number of research papers from the Northern Ireland Assembly Research and Information Service on access to justice, one of which considered the issue of alternatives to court proceedings. This research paper, which is available at our website, considered comparative developments in other jurisdictions, such as the Family Justice Review report in England and Wales, which recommended promoting the use of mediation and collaborative law in family cases, proposals on draft alternative dispute resolution legislation in the Republic of Ireland, and the family dispute resolution model in Australia. And I'm sure our committee would be delighted to have a look at the one in Australia if that was felt appropriate. I'm sure we'd be very keen to go and have a look at that and see how it works out. I'm only joking. This leads me on to introduce then Professor Jack Anderson from the School of Law at Queen's University. He is the author of a public information booklet on alternatives to court in Northern Ireland, which was produced jointly by the Northern Ireland Ombudsman, the Law Centre and Queen's University in September 2011. This work was welcomed by the Head of Access to Justice Review Team during his briefing to the committee. We are delighted that Jack can join us today to present his paper promoting alternative dispute resolution in Northern Ireland, which includes suggestions as to how alternative dispute resolution can be better promoted. This research will be very useful in contributing to the public debate and in informing the Justice Committee, who I know will be taking a great interest in how the recommendations of the Access to Justice Review, including those relating to alternative dispute resolution, are implemented. So can I, at this point, welcome Jack to the seminar. I apologise, I need to leave, but I'm sure everyone will find the information very informative. Thank you very much.
Great. All right. Well, good afternoon. And first of all, thanks to the organisers of this exchange here behind me for this opportunity, and thanks to the Chair for his gracious comments, and thank you for attending today's talk. I don't think we'll get it, fully to 35 minutes, and certainly throughout this, I'll try and make it kind of as interactive and as accessible as possible. The thrust of this kind of presentation, it's essentially fourfold in nature. And it's based on a booklet which is there before you, and I can give you copies of it later, a public information booklet that the School of Law was involved with, essentially that I wrote, but also was produced and published by the NI Ombudsman and by the Law Centre NI as well. And the booklet, it attempted to show members of the public, and it still does attempt to show members of the public, that there are ways other than litigation to resolve your dispute. That's essentially the thrust of this, and how these alternatives to court might work and where you can access them. And that was the essential three-point aspect of this. And the stress is on how mediation, conciliation, arbitration, etc., is a better means. Better in terms of time, in terms of privacy, in terms of cost, in resolving disputes as compared to litigation. And that was the central thrust of that. And then thereafter, and I'll give you copies afterwards, it gives a detailed directory of dispute resolution services such as we could find at that time. And it is also available online through NI Direct. And hopefully maybe after today in every constituency office of every MLA. So we've tried to make it as freely and as publicly available to everyone as possible. And in discussing that document, I just want to kind of make 4 broad points, and I'll leave it at that really. And the 4 broad points is, first of all, what was the motivation underpinning the drafting of this document? Why did we decide to do it? Second of all, what it contains, just go into a little bit more detail of what it actually contains. And thirdly, and probably most interesting, the anecdotal evidence that arose when we kind of started researching this. The anecdotal evidence as to the status of ADR in NI at present. And that, information was gathered anecdotally from members of the public, from those operating in the ADR community, from the legal profession, and most interestingly, what the judiciary's opinion on it was. And that anecdotal evidence in the first half of next year will be the basis of a formal research grant that I'm carrying out with the Nuffield Foundation on ADR in Northern Ireland, £20,000 grant, and where we'll map and see what's going on in ADR in Northern Ireland. So that'll be a more formal thing. And thereafter then the 4th point that I'll make, and the 4th and final point, is just some comments on the future of ADR in Northern Ireland, and is as informed by a comparative perspective. Not just the US and Australia, but other parts of the UK. What's going on in England and Wales, what's going on in Scotland, and what's going on in the other Irish jurisdiction, what's going on in the Republic. So they're the 4 kind of points that I want to make. And so I suppose the first point then is, what motivated us to draft this alternative dispute resolution directory, if you like? And I suppose from a selfish point of view, and you're going to have to bear with me here for a second, at Queen's we've reintroduced an alternative dispute resolution module. We hadn't taught it for years. And it's something that the students liked and something that they took on. It was very much a research-based module. And so we set them various tasks and let them free in Northern Ireland to talk to alternative dispute resolution providers. But one of the important things that came out from it is that this idea that I've put up on the information slide here, this fragmentation of the ADR community. What do you mean by alternative dispute resolution? Who provides the services? Where can you access it? And where can you find out information? And one of the things these students found out is that it was very difficult. If it's difficult for law students and all the resources they have, it must be difficult as well for members of the public. And that was essentially the thrust of the motivation behind the writing of this document and the future research that will take place. So that's an important point, I suppose, to make. Essential weakness of alternative dispute resolution in Northern Ireland is its fragmented nature. I think that's definitely the most important point. And it came out from the research that these students did that in England and Wales they had a central depository, a central directory for alternative dispute resolution. It was the same in Scotland. We had nothing in Northern Ireland, and therefore we decided to take the initiative and to begin a very small baby step in promoting alternative dispute resolution through this information booklet. And hopefully it has started the debate, along with the Access to Justice report, about promoting ADR. So that's the kind of the first point that I want to make on that, this idea of the fragmentation of the ADR community. And actually, it's an important point that is picked up by the judiciary in Northern Ireland and by the legal profession as well. If you compare the legal profession, I know there's representatives here, you compare them to the ADR community, the legal profession is a very unified, powerful lobby. The ADR community has no effective centralised lobby. And that's an important point, and a point that we'll come back to as we go along. So when the legal profession says, rightly, we must do our degree for 3 or 4 years, our professional qualification, all the continuous professional development, and yet you can become a mediator by doing a weekend in a local hotel, where is the balance? That's the argument they make. And it's a very powerful argument, and it's a powerful argument in terms of the privatisation of civil justice. That's an important point that I'll come back to in a few minutes, and how we can deal with that. Now, this ADR initiative, it's not obviously Northern Ireland specific, and we tap into other initiatives that are occurring throughout Europe. For example, there's a relatively recent European directive promoting cross-border mediation. The Jackson report in England and Wales has stressed the need in terms of civil and criminal legal aid to provide alternative means of dispute resolution. In the South, they have promoted it through an arbitration act and a forthcoming mediation bill, and obviously we have had the Access to Justice report here in Northern Ireland, and all stressing the need to promote publicly and uniformly the advantages of alternative dispute resolution. Okay, so that's my kind of first general point on this. And I think what comes through all of this, and from all the various jurisdictions mentioned, is that the huge advantage, and I noticed the chair here, the chair of the Justice Committee mentioned it as well, the savings on costs is a huge point. This seems to be the key promotional point about alternative dispute resolution, that it offers a cheaper, quicker, less adversarial means of resolving disputes. Okay? And I'm not going to go so much into the legal aid argument, we've both criminal and civil, although we can kind of mention it later in questions. But just to give you other areas, which is interesting. This year the Northern Ireland Audit Office, and you can see it on the column on the left there, look at the bill for settling medical negligence cases over the last 5 years in Northern Ireland. 250 million. It's a huge amount of money. Imagine if mediation was half as effective. That's 125 million available to spend on other things. And look, from 2010, these ongoing medical negligence cases and the amount that it's costing in terms of legal fees. Is there alternatives to dealing with this? And there are alternative means of dealing with this, and arguably these alternatives are more cost effective. So that seems to be the major point when it comes to alternative dispute resolution. Okay, and that brings me on then to my kind of second point, which is the contents of this alternative dispute resolution booklet. And I'm not going to go into it in detail, but just to kind of give a general emphasis on it. The first thing is it gave a very broad, not very prescriptive definition of ADR. What is alternative dispute resolution? Okay, and we'll go into that in a bit more detail. In the booklet, it did not talk about international arbitration or international mediation. In Scotland and in Ireland, they promoted arbitration through two recent acts, 2010, in both jurisdictions. And they made a big play about Dublin and Edinburgh and Glasgow becoming centres for international commercial dispute resolution. That's not going to happen. It's not going to happen because London has the market and will retain the market. Okay? So what we decided to do is to promote mediation and arbitration from a domestic point of view, and how it can resolve disputes domestically, including commercial disputes, including personal injury disputes, and most notably, family law disputes. Okay, so that's what we have emphasised. The second thing in this alternative dispute resolution booklet was that we kind of had an emphasis on the advantages. And, I'm not going to go through the advantages, in great detail. They're pretty obvious and everyone here will know about them. But we just wanted to stress those advantages. But we stressed them with a caveat. And that caveat, it will come out kind of later, that in some, not all disputes are open to alternative dispute resolution. Okay, and that's a very important point. And also, it is important that those entering into it get some sort of independent advice, be it from a Citizens Advice Bureau or an independent advice centre, or obviously a solicitor. Okay, and there are certain examples of that which we'll talk about in a few minutes' time. So that, and that's important. So, and thirdly and fourthly, then we had the various types of ADR and examples in the form of a directory. And in all of these instances, as I said, we were taking a kind of a bottom-up approach. How would you resolve a dispute with your neighbour, with your retailer, with your local hospital? All of these basic disputes, which sometimes can unavoidably and expensively end up in litigation. Is there an alternative means of doing that? Okay, and sorry about the kind of small print on this, but this was the kind of system that we used, whereby if you take it, the actual dispute itself is right at the bottom there, and then we have a kind of a circular, or you can do it in a linear way of dealing with the dispute. And in one way, the emphasis is on alternatives, and in one way, the other emphasis is on litigation. And the whole point of this, and the whole point of this booklet, is that we are trying to promote, and what we mean by alternative dispute resolution is that we're trying to promote that this dispute is resolved as near as possible in time and space to when it actually happened. To put it kind of colloquially, it's better to resolve the dispute on the steps of your neighbour's porch rather than on the steps of court. Okay, that's the point that we're trying to push. Okay, and you can see the various ways that it does, in that. And one of the points, one of the first and very simple points we make, whether it's a neighbour dispute or a commercial dispute, sometimes it is best simply to walk away from a dispute. Sometimes a debt is a bad debt, you live with it and you move on, and you can save yourself a lot of time and effort and expense in that. And then we resolve around from negotiation, mediation, all the way through to it. And I just want to pick up one or two points that came back to us in preparing this. The first point is on mediation. One of the points that just came through to us, and it's a significant point from the legal profession in particular, is that mediation is a difficult thing to do in a family type situation, for example. The mediator has to be very, very well qualified and experienced to ensure that they stay neutral, to ensure that they promote confidentiality, and that they avoid just settling an argument or a dispute just for the sake of reaching a settlement. Okay, and it's very important as regards the qualifications for mediators and whether the existing qualifications are fit for purpose. That's the point that came up to us. Neutral experts or early evaluation or determination of disputes came up in construction disputes in particular. Arbitration came up. And arbitration came up as a significant problem. And the significant problem is that, and I practice as an arbitrator, is that people are moving away from arbitration. This is the international trend, because it is becoming as formalised and as legalised as ordinary court proceedings. What's the point in going to arbitration if it's going to be as formalised, as slow, and possibly as costly as ordinary legal proceedings? In fact, the arbitration dispute will be resolved in private. You won't even get your public validation as you would in court. And that's an important point that has come up time and time again. And then we move on to the regulatory things, by which I mean ombudsman and those type of scenarios. And one of the things that came up on this as regards, for example, the NI ombudsman, is that there seems to be an understated nature to their role. They have a significant role in resolving disputes relating to health, relating to planning, and relating to a wide range of government agencies. And in some way, and this is why I think the NI Ombudsman got involved, they're underselling what they do and what they can do. Okay, and that's an important point. I know Marie Anderson at the NI Ombudsman's office always says, you know, you do basic market research. If you ask most people in Northern Ireland about the word ombudsman, they'll associate it with the police ombudsman. Okay, and there's an obvious example of how it's underselling. We did a little bit of work on the tribunals, the existing tribunals, and one of the things again is the length and intricacy of these proceedings, and whether or not we have to look again at the employment tribunals. And actually, as a sidebar to that, a very small amount, and it's something I'm going to do a little bit more on, is a small claims court. Significant public dissatisfaction with the small claims court and the way it's actually operating, and whether or not local mediation would be a much better way to deal with it rather than this on the paper small claims situation. So there's kind of some of the feedback we received in preparing this, and some of the feedback that gives you a kind of just a brief insight into what's going on in Northern Ireland alternative dispute resolution. So the next step is what it contained. Well, it was at the time a very detailed directory with excuses to the Bar Library, who we didn't include something from them, but a fairly detailed directory on alternative dispute resolution mechanisms such as they existed in Northern Ireland at the present time. Actually, one of the things that we found was very interesting is that people were very interested in how to complain about estate agents. Okay, that seemed to delay us quite a bit. You know, we had to put in quite a number of that, on that, good and bad. But, you can see from benefits, consumer issues, right down to sport, victim and work-related issues. All of these issues were detailed in this alternative dispute resolution directory. And that kind of brings me on, I suppose, for you, what are the key kind of reflections that we got generally from this? And I'll just kind of maybe take my time on this maybe a little bit more, and we can tease it out in questions and answers. We focused on four kind of elements as regards reflections. What the public thought, the ADR community, the legal profession, and the judiciary. Starting with the public. And two things about the public. Now, I stress this is anecdotal, and I hope to kind of do a bit more empirical work on this later in the new year. First, two things about the public. First of all, from the public, to put it bluntly, an ignorance about ADR, a lack of knowledge about alternative dispute resolution, maybe a vague knowledge about citizens' advice bureaus, but really a lack of knowledge about ADR, something that came out to us in great detail. I mean, I've mentioned the Northern Ireland Ombudsman as an example of that, and its role, as regards supervising public bodies, essentially unknown to large members of the public. I would have to say that, and also things like its role in planning disputes. Okay, so that is straightforward, distinct lack of knowledge about the from the public. Okay. The second thing from the public is that when you talk a little bit more about alternative dispute resolution, and they tend to hook on, people tend generally to hook on to mediation and to a certain extent arbitration. They like, in some ways, the privacy aspect to it, but in other ways they don't. And one of the things that they really like, obviously, about the court system is that they get their day out in court and they get it validated publicly that I was wronged. Okay? And that is a significant aspect that should not be underestimated. The constitutional right of access to the public administration of justice is a point that came out time and time again for us from the public. And it is something that those who work in the alternative dispute resolution community will have to think about themselves. Okay, so that's the first thing about the public. The second thing is, I suppose, the ADR community itself. And the ADR community itself is guilty of not just being fragmented, but tolerating that fragmentation. There is no central lobby group. Now, recently, under the guidance of Brian Spears, there has been an attempt to kind of generate what is kind of grandly called a Mediation Council of Northern Ireland. There has been efforts to promote that. But that's in or around the first real effort that has been made to promote ADR in Northern Ireland, and to do so from a kind of a centralised point of view. And the second thing is that the ADR community has not of itself promoted what it does and promoted its distinct advantages. And it has not dealt with the issue that was raised with the public, this issue about the hard remedies that you can get in court as opposed to the quicker, softer remedies that you can get in alternative dispute resolution. And we can talk about those later. And when it's explained to members of the public that you don't have to enter into litigation to get what you want, which may simply be an apology. You don't have to get a declaration in court. You can get a simple apology. Then things begin to unravel, and ADR seems to fill in the gap there. So that's an important point. There needs to be more robust encouragement of ADR by the ADR community itself. The second thing is that ADR in Northern Ireland is at a very, kind of lowish enough level. It's at an early stage in its development. And of course, as a delicate flower, it has to bloom within a very large shadow, and that large shadow is the legal profession, straight out, the legal profession. And what is the legal profession's attitude to alternative dispute resolution? I'm conscious there's a member of the Law Society here, so I'll be nice and polite to begin with anyway. So there is a suspicion, maybe even a certain hostility towards alternative dispute resolution, And it's the old joke, ADR, another drop in revenue, and that's what you get trotted out. And particularly, in straitened economic times, this is. And the questions that must be asked, and these questions can only be answered if you engage properly with the legal profession. And the legal profession is providing more and more means of alternative dispute resolution. The Law Society has its scheme, as has the Bar as well. So they are providing it. And one of the questions that is asked time and time again is, why is it, as compared to other jurisdictions, such as the US and such as Australia, why is it that ADR is seen as a threat? And why isn't just seen in an alternative as an extra element of the skills that you have and the revenue stream that you can generate? Okay? Why don't you turn the argument on its head? And given that lawyers have advanced negotiation and settlement skills as it is, why don't they feed more in to the alternative dispute resolution? Is it because they can't charge as much? That is bluntly the case, and that is something that has to be asked. And if ADR has the manifest advantages that it says it has in terms of cost, in terms of time, in terms of privacy, is it in your client's best interest that they be directed to it first before any further consideration is given to how to resolve the dispute? Now, you have to be pragmatic about this. ADR in jurisdictions such as the US and Australia has been taken on board and is enthusiastically followed. But it's only enthusiastically followed in the US and Australia because it was mandated in legislation. And it was mandated in legislation that in the early stages of disputes, and particularly family disputes, ADR must be considered. All right? And that is an interesting point that has been taken on board. And it is mandatory in certain civil, commercial, and family law proceedings. Okay. Mandatory mediation is not on the agenda in the UK. There are, as ever in law, certain human rights aspects to it. You cannot mandate people to take an alternative to court, given that the right to court is a constitutional right of access and ties into Article 6 of the European Convention of Human Rights. That seems to be the argument. Now, funnily enough, other European jurisdictions such as Italy, etc., ignore all that and have mandated it for certain commercial disputes. But in the UK, there seems to be this strong human rights element. We can talk about that in a sense. But what has come into effect, particularly in the courts in England and Wales, is that where parties have have unreasonably refused to engage in ADR at an early stage in the dispute, they have been punished subsequently by way of costs. And that seems to be the robust way of encouraging dispute resolution. You know, where you unreasonably refuse to mediate, you may face punishment as regards costs. And there is significant Court of Appeal jurisprudence in England and Wales on that, and it is feeding into this jurisdiction as well. So that seems to be the kind of process on that. Okay. Other ways of promoting ADR, the courts themselves have embraced it. And in certain areas, there are pre-action protocols in the courts of Northern Ireland which promote alternative dispute resolution. In personal injury, in clinical negligence, in commercial, in defamation proceedings. There are pre-action protocols which are supposed to force you to consider ADR, first of all. How effective these are, we're not quite sure on that. Though it is interesting that in the Leveson inquiry, which if you have a very sad life like I do, you read some of it, even most of it. It is one of the points that comes out by Leveson is that we talk about privacy, and even we talk about defamation, but they're essentially, given the costs, celebrity torts. Where is the access to justice point of view? And it's interesting that one of the kind of forgotten things that Leveson has argued is that whatever way the press is regulated, the dispute resolution will be alternative by means of arbitration and mediation. And that's kind of one of the things that has been slightly underestimated by Leveson. In Northern Ireland, one of the ways that has come up of promoting it through the Access to Justice report has been, well, there's two things. First of all, financial incentives to encourage mediation in publicly funded cases. In other words, making it a condition of legal aid that ADR is considered. That's one thing. And the second thing, that all government departments in Northern Ireland commit to adopting ADR mechanisms to resolve disputes with the public and suppliers. In other words, that the example comes from government bodies, so that they commit therefore. It's something that in the Republic has been taken on board, and in cases like procurement and tendering issues, it has seen a significant cost saving. So it's maybe something that has become, might be taken on board here. And the last thing that has come across in the Northern Ireland Access to Justice Review, and it's come across in recent reports as well, is that be pragmatic about it. Start a pilot programme on ADR, focus on family law, and see does it work there, and does it work efficiently there, and if it does, then you can extend it. And that seems to be the pressure point that will be exploited, and I know that the judiciary are quite open to that as regards family law. Okay. So two final points, and then I'll leave it at that. As regards the legal profession and their, I suppose, suspicion of alternative dispute resolution. One of the things that the legal profession are very good at pointing out to me time and time again is there is work by an academic at the University College of London called Hazel Genn, who has investigated local mediation mechanisms in London. And it has pointed out that mediation, there's a number of problems. Costs aren't as effective as you think. It is sometimes much slower than you think, and has been exploited by certain parties as a tick-the-box exercise. So we'll go to mediation, we'll delay it until the inevitable proceedings. Okay? And that has been important. There are problems with privacy, confidentiality, and the binding nature of mediation agreements. And her point, Professor Genn's point, which is kind of summarised in one simple quote, mediation can frequently get people to compromise on basic substantive rights, in the sense that the outcome of mediation is not about just settlement, it is just about settlement. And that's a point that she has made and has empirical research to back that up. In other words, mediation should not supplant the ordinary justice system, but should supplement it. And that's, and that is pretty, a pretty strong point that has been made on that. And that in some ways, if we take it, governments like to adopt mediation and alternative dispute resolution as an excuse or a diversion from cutting the legal aid budget. And that in cutting the legal aid budget, you are cutting and denying access to justice. And there is an argument made by Professor Genn on that point. And the last point is the attitude of the judiciary. Well, the judiciary are pretty open enough, and a number of them have pushed these pre-action protocols trying to divert disputes into alternative dispute resolution, but a number are not. And what they are extremely aware of, and there may be a role for the universities in this, is this idea of the privatisation of civil justice. Some of these disputes, family, commercial, personal injury, are complex disputes. You have to ensure that there is quality control there as regards who exactly is hearing it. Okay? Can we just hire it out to mediators and we're not quite sure how they are qualified, when they are qualified, are they undergoing continuing professional development? And it's a very, very strong point that the judiciary make time and time again about this assigning power and responsibility over key disputes to essentially private individuals or private entities. And there is a problem they have with the public administration of justice in doing that. So there are some of the kind of issues that have come up time and time again as regards alternative dispute resolution, and they kind of manifested themselves in this booklet. And but that's the last kind of quote I'll give you from Voltaire. He used to play left back for France. He was quite good. And he said, you know, I was ruined but twice in life, once when I lost a lawsuit and once when I won. And the point is, how do we strike the balance? There are advantages of alternative dispute resolution, but there is this constitutional right of access to the courts. How do we strike the balance where both work together? Rather than supplanting one another, they supplement one another. And so that's the essential nature of my paper. So thanks very much for listening. All right.